Okay, the number is looking quite steady now in terms of participants, so I'll make a start. So today's webinar is on the topic of disclosure. You will all be aware of that, you've all booked on for it. It isn't the most exciting topic, I have to admit, and I think a lot of people will share my view with that. But it is incredibly important due to the impact it can have on a case if it's not carried out correctly. So I think it's really important where it is something that's sort of difficult and people dread to be extra vigilant when you're carrying out these things. And that's why it's important to know sort of the background and what can happen if you don't carry it out correctly. For those who haven't attended a webinar carried out by myself before or haven't worked with me, I'm Sam Robinson and I work within the housing and regeneration litigation team at Forbes Solicitors. So I've got a background in working in lots of different areas, including ASB matters, housing management, disrepair, also recently taken on some leasehold extension claims as well as complex queries. So I've got quite a sort of broad background in different things. I've dealt with disclosure from the viewpoint of a claimant and from the viewpoint of a defendant. So I've had both experiences there. So in terms of what we are going to cover today, it will be what does disclosure mean? What needs to be disclosed? How does pre-action disclosure differ from disclosure within court proceedings? Some of this might not be relevant to you. Obviously, you're all coming from different providers and different backgrounds and have different reasons for joining. Depending on what sort of practice area and thing you deal with, parts of this won't be relevant to you. Other things we're going to cover are what are the limits of disclosure, what is specific disclosure, what is inspection, and what happens if I fail to disclose something. So as you will be aware, disclosure is not something which is relevant in every single case you will deal with. It is something which, on the most part, you won't need to deal with before a first hearing if we're talking from a standpoint of perhaps breach of tenancy matters, so injunction proceedings, possession proceedings on the back of sort of rent arrears or antisocial behaviour or some other breach of tenancy. It is something which will be ordered in possession cases should they not be resolved at the first hearing and you've got directions to trial. Generally, it's not set in injunction proceedings if it does go sort of all the way to trial, but I have seen it and I've got a case at the moment with it. So it is a good idea to sort of keep refreshed with it because it might pop up when you're not expecting it on a case. So in terms of what does disclosure actually mean, I think a lot of individuals who are new to legal work get confused with disclosure. I'm pretty sure that I have in the past as well, before I started dealing with things quite routinely. I think a lot of people think that the whole process, or more specifically the handing over the documents, is the disclosure part. It's actually in a few parts. So there's disclosure, requests for those documents, and then inspection. The provisions relating to disclosure are contained within Part 31 of CPR. Doesn't apply to small claims track matters, but I think routinely most people who are attending this webinar will be dealing with fast track matters. CPR 31.2 states a party discloses a document by stating that the document exists or has existed. A document doesn't need to be sort of a Word document or an Excel. It means anything in which information of any description is recorded. So it could be a photograph, it could be a video. There are lots of different options. So in terms of what needs to be disclosed, documents which are or have been in a party's control. So, i.e., it is or was in their physical possession. They have or have had a right to possession of it. They have or have had a right to inspect or take copies of it. Disclosure isn't just limited to documents which are in a party's control, but extends to documents which were in a party's control. In terms of what needs to be disclosed, so this is the document upon which that party relies in relation to their case. So it can include documents which adversely affect their own case, adversely affect another party's case, or support another party's case. the documents which they require to disclose by a relevant practice direction. A party need not disclose more than one copy of a document, so it's not something that's meant to be overly onerous. It is quite an onerous task, but it is limited in that way. It also includes a copy of a document that contains modification, obliteration, or other marking or features. That should be treated as a separate document. So sometimes there can be sort of a few copies of different things. They are different documents, and it's better to set them out in that way. A copy in relation to a document means anything which information recorded in the document has been copied by whatever means and whether directly or indirectly. You will be aware that it is sometimes necessary to redact a document. This can be for a number of reasons. I have seen some clients' case files documents contain sort of details of all individuals who've been tenant throughout the ownership of the property, or perhaps it contains details of prospective tenants who were potentially looking to take on that property. Obviously, that information should not be shared with the other side and isn't going to be relevant in that case. Other things that you might need to redact include sort of neighbour complaints, if it's an ASB case, which you've not got permission to share and haven't been included within your case. Police information, that could be another thing that you need to redact as well. In some cases, you're giving information that is sort of a little bit off the record, and due to worries of affecting maybe a criminal case, you can't share that. So that's something as well that you can't share. So the procedure for standard disclosure, which is what you would do most of the time, each party must make and serve on every other party a list of documents. The document must identify the documents in a convenient order and manner as concisely as possible. So that is sort of the wording as per CPR. I have put a copy of the court form that you'd need to complete on the slides. I do appreciate that it is very, very small, so you can't read that, but most of you will be familiar with the document and what it includes anyway. That relevant court form is the N265. Quite frequently, you'll find, especially if you're doing disclosure on part of, whether you claim an or defendant, if you're a landlord, there's likely to be a lot more documents than the other party's got. So quite frequently, there are too many documents which need to be disclosed to fit in the court form. It is quite small, and I think it can sometimes be quite hard to work with. It's perfectly acceptable. I mean, we do this all the time to create something like a Word document which has a court header on it and list all the documents within it. I always list documents chronologically by date and have any undated documents or documents with various dates listed at the bottom. If you do miss a document when you're going through and creating that list, sort of when you initially create it, or it comes to light after you've started the list, but before you've sent it off to the court on the other side, it isn't the end of the world to add it to the bottom, as it can be very tedious and time consuming to have to add it in the correct place and then have to renumber everything. I think everyone will probably have their own technique in terms of preparing the disclosure list. There's no real quick way to do it. So I think that's why you've got to be very, very vigilant. It's better, really, if you can, obviously not to break off when you do it, to set aside time and get it started very early. The best way that I've found is to rename and date your documents in your case management system, and use the same name that you're going to use in the disclosure list. So, for example, I've seen some documents from our clients that have maybe just codes. It's just a list of numbers, and I don't know what it is until I click on it. So I'd rename that, for example, Gas Safety Record 2024, potentially the actual date of it as well, because that's going to be on the disclosure list. When you finish your list, you can then easily number them. So I would number them as per the list again. I'd always recommend getting someone to check it if you're carrying it out yourself. It's something you could easily make a mistake on, misredacting things, miss a date, etc., especially if you've got sort of hundreds of documents, which isn't that uncommon to see. And it's also a lot easier for somebody to check it as well if you've carried it out in that manner. It's very clear and concise, and it's hard to get it mixed up. In terms of the court form, I'll just go back to that again briefly. So as again, I appreciate it's very small and you can't see the boxes. But some of the things you'll be including. So more often than not, your search for documents won't predate the tenancy date. That'll be obviously if it's, for instance, a breach of tenancy case, they're not breaching the tenancy when they're not a tenant. There might be some other cases where things that predate tenancies might be relevant, or perhaps in cases such as failed succession cases, the individual isn't actually the tenant, but you're probably going to be referring to the tenancy or previous things like stock transfer promises and things like that. So not every case will be sort of tenancy start date as the beginning point, but more often than not. Categories you might include in terms of your search would include things like liability, causation, and quantum if it's a disrepair case, or perhaps in other cases it will be those relating to the party, whether that's the claimant defendant and their breaches of tenancy. In terms of Section A general documents, that'll include party-to-party correspondence and pleadings, as well as documents which have already been disclosed and are common between the parties. Part B is specific disclosure, which will be your list that we've referred to, that Word document. You'll set out which documents you object to an original copy of being inspected, and so you will need to know which documents you are redacting when you prepare this list. Even if due to time constraints, you have to simply put a note to yourself to redact it and do that at a later date before you provide in the documents. So in terms of a duty of search, when giving standard disclosure, a party is required to make a reasonable search for documents which may be disclosable. The factors relevant in deciding the reasonableness of a search include number of documents involved, the nature and complexity of proceedings, the ease and expense of retrieval of any particular document, and the significance of any document which is likely to be located during the search. If a party has not searched for a category or class of documents on the grounds that to do so would be unreasonable, this must be stated within the disclosure statement. So, for instance, in a disrepair case, it may well be that your antisocial behaviour records obviously aren't massively relevant to that. It may be that you have a wealth of information in relation to rent possession rent matters and rent arrears, but rent possession proceedings aren't what the proceeding's about. Maybe it's, again, antisocial behaviour. You might have a lot of letters on your systems chasing arrears. It's probably not going to be very relevant. And it's time consuming for everybody involved if that is included within disclosure. If the party making the disclosure statement does so on behalf of a company, firm, association, or other organisation, the statement must set out exactly who is making the statement and why they are considered the appropriate person to make the statement. So I think for everybody involved here, that will probably be the case. The statement you'll be making will be something along the lines of your name, for the party, so claimant defendant, oversee the handling of this case. I have access to the party's records and databases, and I'm familiar with the issues in dispute so as to make effective disclosure. I confirm that I have the party, again, claimant defendant, authority to sign this document. Disclosure statement, as I said, should set out the extent of the search that has been made to locate the documents which are required to disclose, and certify that you understand the duty to disclose and that you've carried out to the best of your knowledge and ability the search. In terms of the location, obviously you're probably going to be putting something along the lines of you've searched within the offices of your organisation and the solicitor. In terms of electronic search, that could be your electronic systems, databases, and email servers. Again, this is one slide that probably won't be relevant for everybody. So there's pre-litigation disclosure and there's disclosure that takes place within a litigated case. So I routinely deal with pre-action disclosure. So the aim of this is to dispose fairly of anticipated proceedings, assist the dispute to be resolved without proceedings or save costs. Generally, pre-action disclosure is more limited. So I do this for disrepair cases. The other party will specify exactly what type of documents they wish to have sight of. So this in disrepair cases would be sort of repairs records, contact records, cyclical maintenance checks and letters. So in terms of the disrepair process, the requirement to disclose documents is set out within the pre-action protocol. Obviously, there won't be protocol in terms of all types of matters that you're dealing with, but luckily for that, there is. And it is hoped that the parties will resolve the matter without the need for litigation, whether that be because it's discovered that there's no case, so there might be no notice in a disrepair claim, there might be repairs that just haven't ever been reported, and client staff members and contractors haven't ever been able to gain access and been aware. Or perhaps there is something there and the parties do resolve the case outside of court. So if the party who receives the request for pre-action disclosure doesn't complete the disclosure exercise, there is a risk of a pre-action disclosure application being made against them. This is something which can be made without notice. The court can only make an order where the applicant or respondent are both likely to be a party to subsequent proceedings. So in a sort of proposed disrepair matter, so that's quite clear. In terms of the application, there'll be an N244 application form, draft order and witness statement. So that will set out things, sort of the initial request, the chasers, and any response or lack of response, which has probably led to this application being made. If the court grants the application, they'll specify a time period by which the defending party must complete disclosure. They might also make an order for costs, which could be in the region of a few £100s. So obviously this is to be avoided if possible. Sometimes things do slip through the net, but best to avoid getting into this situation. What I would say is if deadlines have expired or are close to expiring, the best thing to do is act very quickly. Hopefully before the other party have had an opportunity to make an application and ask the other party for an extension. I do find usually they are willing to agree to that, especially if I can say, look, I understand disclosure has passed by a day or is due in a couple of days, but I've just now been instructed. I don't have all of my client's documents. They generally will agree to that because obviously it is quite a lot of effort for them as well. And generally they're only going to be getting the costs back that they have incurred if they are successful. So more often than not, as well as considering obviously court times as well, that can be quite lengthy. So if they know they're going to get the documents imminently, that's the best situation for everybody. And the court also could make an order for disclosure against a person. This could be somebody who's not party to proceedings. The documents which are sought are likely to support the case of the applicant or adversely affect the case of one of the other parties to proceedings, and where disclosure is necessary in order to dispose fairly of the claim and save costs. So it's all about the overriding objective, getting to the end goal and saving costs and time for all parties. As an example of where this may occur, I think it's quite rare that you would really see it, but it may be in tenancy fraud cases, for instance. So you might seek disclosure from an energy company, sort of accounts registered to the property and usage to help you decipher what has happened and if you have actually got evidence to proceed with any case that you might want to initiate. What are the limits of disclosure? So a party to whom a document has been disclosed has a right to inspect that document, except where the document is no longer in the control of the party who disclosed it. The disclosing party needs to indicate what's happened to any documents in these circumstances, why they're no longer in their control. Another example is the party who disclosed the document has a right or a duty to withhold inspection. We'll come back to that later. Or where a party considers that it will be disproportionate to the issues in the case to permit inspection of documents within a category or class of documents. Again, it must be stated in the disclosure statement that inspection will not be permitted. So what can be withheld coming back to that? So that could be, we've talked about it before, redacted documents. So obviously the originals, you're not going to be disclosing those for whatever reason it may be that we've discussed earlier. It could be documents covered by client solicitor privilege, information which relates to a third party. I mentioned it earlier, so anonymous complaints or other information that you can't divulge. So privileged documents do not need to be disclosed. So this includes legal advice privilege and litigation privilege. Legal advice privilege protects communications between a lawyer and a client that are made for the sole or dominant purpose of giving or receiving legal advice. Litigation privilege protects communications between lawyers or their clients and any third party for the purpose of obtaining advice or information in connection with existing or reasonably contemplated litigation. Information which does not relate to a case obviously can also be withheld. It's not listed specifically on the slide, but obviously I've gone through that earlier. Where a party inadvertently allows a privileged document to be inspected, the party who has inspected it may use its contents only with the permission of the court. What is specific disclosure? So the court may make an order for specific disclosure or inspection. So it could be disclosure of documents or classes of documents specified in order, carry out a search to the extent stated in the order, and disclose any documents located as a result of that search. Specific disclosure is essentially what it says on the tin. It might be sort of quite obvious to one party that the other party hasn't disclosed a certain document, and if they've got a reasonable sort of suspicion or strong suspicion that that will exist, then they may make an application for specific disclosure. You'll all probably know this. Obviously, there's an ongoing duty of disclosure within cases. So any duty of disclosure continues until the proceedings are concluded. As such, if documents come to a party's attention any time during the proceedings, they must notify every other party. As a side point, a party may apply for an order for inspection of any document mentioned in an expert's report which has not already been disclosed in the proceedings. An example of ongoing disclosure, again, I'm going to use the example of disrepair cases because this is what I'm most familiar with on a day-to-day basis. So there's likely to be updated repair records. Obviously, if you're going in to get any works done, perhaps there's going to be letters relating to access for cyclical maintenance or something similar. Obviously, access issues can sometimes be relevant in disrepair claims, where the claimant is saying that the reason we haven't got works done is due to a lack of access. Obviously, it's not a complete bar, but it is relevant in proceedings. Another example, if your case relates to breach of tenancy, there might be further reports which you have permission to share and are contained in your records. Inspection. So what is inspection? Disclosure may take place in stages. It could be ordered or agreed that it will all occur on different dates, with a disclosure list being served, requests for all or some of the documents, and then inspection taking place. That's the most common way that I see it done. I think it can be quite hard to get the list to the other party and the documents on the same day. And if you do that as well, if there might not be time for the requests, and you might simply be sending all of your documents just simply to comply with that deadline. Obviously, you might agree an extension. There's provision for that sometimes, and there's possibilities there. But I think it's much easier to have it diarised in different parts and at different stages. Because if you're sending everything in a rush because you are in the last minute for whatever reason that is, things happen, it's litigation. You might be sending across a lot of documents, which takes a lot of time for you, and the other parties then having to pick through all of that. If you've labelled it well, they might not pick through every document. Some people might prefer to review a document that is labelled in a way which suggests it isn't relevant and they don't need to see it, but they might prefer to just see it in any event. That's only going to increase costs on the other side. So yeah, I always prefer to set it out with specific dates and not all on the same date. We generally see a date for requests to be submitted sort of around 7 days later. Yeah. Going on to inspection. So the parties obviously will exchange the disclosure lists, and then each party will receive written notice of a wish to inspect a document, which must be given to the party. Inspection must be permitted not more than 7 days after the request is made. I have actually in practice seen this longer, but generally sort of 7 days should usually be sufficient. Parties may apply even without notice for an order permitting them to withhold disclosure of a document on the ground that disclosure would damage the public interest. I haven't ever seen that happen. I think it'd be quite rare. So going on to perhaps one of the most important slides, or important to know slides, what happens if you fail to disclose something? So proceedings for contempt of court may be brought against a person if they make or cause to be made a false disclosure statement without an honest belief in its truth. Proceedings under this rule may be brought only by the Attorney General or with permission of the court. So I think it'd be quite rare that this would happen, but there is provision for it to happen. A party may not rely on any document which he or she fails to disclose or in respect of which he fails to permit inspection unless the court gives permission. So obviously it could negatively impact your case if you haven't disclosed or you haven't allowed inspection. As we know, the possible consequences in terms of contempt proceedings can include no order if you're fortunate, fine, seizure of assets, or a prison sentence. So it can be very, very serious. Some general tips and reminders. So first of all, it is an onerous process. It should not be underestimated. Generally, you'll be in a position where you're setting the timelines for things. So it might not be your first direction for whatever reason. If it's not, I would still think about getting yourself in a position to get the task done as early as possible. Even if you are sort of simultaneously complying with other directions and getting other things done. I have had it where I've been sent things sort of last minute, and it is just very stressful. It's not a task that you want to be doing last minute. It's not something you really want to be dipping in and out of. You'd really rather get it done in sort of one block of time. So yeah, never ever underestimate it. Another thing which has caused me issues in the past is sort of the medium of the document. It's important to consider the suitability when you're sending it across. An example, Excel spreadsheets. These can be quite difficult to sort of deal with at times. They're usually best for financial information only. I've previously seen Excel spreadsheets which haven't exported properly. It's clearly missing text, missing code. And if you are on the sort of last minute with things, it only adds to the stress. I've also seen sort of multiple slides within the Excel spreadsheet, so you can navigate across. Or sort of really, really long text box for them. So if somebody is wanting to print them off, which some people prefer to do things manually, pen and paper to review things, it can be quite hard work for them. I've had oppos raise that as an issue in the past, and have asked me if I can send it across in a better medium because I just find it very hard to work with. So yeah, that is something to consider, because otherwise you'll be sort of taping bits of paper together and it's just not easy. Another thing to consider is what you are putting down in some form of document that's permanent. One of my colleagues had a situation whereby a very senior staff member at the top had referred to all residents within that particular town as being thick. So obviously that's really not great. It hints at discrimination, and it creates negative feeling within the case. It's not going to help matters. So just be very, very, very careful what you put down. It might not damage the case per se, but it could lead to, as I say, damaged relationships. If If it isn't possession and you're not going to get an outright order, you've still got a tenant and landlord relationship there, and it's going to create distrust and tension, and it's not what you want to be dealing with. Another thing I would mention is, if you would like to carry out the disclosure exercise yourself and you're perhaps just going to get the law firm to check it, it's probably worthwhile sending a clean copy of the document to the law firm so they can double check that what you've redacted is, what should be redacted has been done properly. And again, make sure you do this in good time, because I've had it in the past where I've been given sort of a day or so to check the disclosure, because my client's been like, well, I've done it, so you shouldn't need much time for it, but deadlines, things come in, so always send it in good time. Another point is to ensure that you redact documents correctly. We've probably all had experiences where we think we've redacted something and the marker pen hasn't quite done it, and you can still read through it, so be really careful of that. That is the end of the webinar.